that Bond is running in response to our members' needs around coronavirus and all the different aspects of the way it's affecting organisations, both in terms of funding, but also staffing, business continuity, the shape of the sector when it comes out of this, and so on. So this session today, really delighted to have an expert panel made up of people from Bates Wells and Hays-McIntyre. And today we're going to be looking at some of the issues around staffing and job retention, in particular the furlough, the coronavirus job retention scheme, looking at different aspects of business planning, cash flow, and how trustees need to be involved, how they can be best involved in decision making, particularly when things are changing so rapidly. I don't know about you, but things change at Bond very, very quickly. You know, what we thought was a normal 10 days ago is completely different now. So we're going to present the speakers one by one. We've got some questions that have been asked of the speakers in advance, but if you want to ask questions, please use the chat box to ask those questions, and we'll take those questions at the end of the each individual session. So to start, I'm just going to introduce Paul Seath, who's a partner at Bates Wells and an employment and discrimination specialist, and he's going to tell you more about the furlough and other aspects of staffing during the COVID.
Okay. Great to join you all today. Can you now see the slides, Lena?
Yes, perfect.
Yeah, brilliant. I'm going to be talking a little bit about some of the governance considerations for international NGOs, and particularly almost all of which are charities, and how you might engage with your trustee board, and particularly in the context of a number of organisations having to think more closely than they might usually have to about their solvency. So I'll be covering this for about 15 minutes or so, I think. So first of all, just a note about the issue of the legal form of your organisation. I would think that almost all Bond members will be charities which are corporate charities, such as a company limited by guarantee or a charitable incorporated organisation, often abbreviated to CIO. You might even be a royal charter body or a statutory corporation. But it may be that some particularly smaller international NGOs are still established as unincorporated charities, such as a trust or an unincorporated association. And this difference becomes particularly significant in the case of a potential insolvency. And the reason is that a corporate charity is a legal person, and so its debts and its liabilities belong to the organisation, and the trustees are not personally liable for the charity's debts unless they engage in what's called wrongful or fraudulent trading, which I'll come on to later. And if you are, however, in that category where the charity is unincorporated, then the charity doesn't have what's called legal personality, and that means the debts of your organisation are actually debts of the people who incurred them, and that's your board of trustees. So if there were not enough money in the charity to pay its debts, the trustees would be personally liable for those debts. And that means that in a situation where there may be concerns about solvency, the stakes are going to be much higher for your charity trustees if the charity is unincorporated. So another thing to be on top of at the moment is thinking about your charity's insurance. So you can insure for a range of different risks. You can't insure for the charity just generally being insolvent and unable to pay its debts. But what you can do is you can have trustee indemnity insurance, which may give your trustees the reassurance that when they're taking difficult decisions about the future of the charity, they are protected if there is a question about whether they have been in breach of their duties as trustees. So that's not going to protect them in the case of an unincorporated charity for the general personal liability for the debts of the organisation. But in the case of both an incorporated and an unincorporated charity, they could be liable for breach of their duty as trustees. And having trustee indemnity insurance can be helpful, for example, in paying for the costs of advice if they are later investigated by the Charity Commission over whether they acted appropriately and responsibly as trustees. So now would be a good time to be checking what the charity's trustee indemnity insurance policy covers and making sure that the premium has been paid. And the other thing to watch out for in trustee indemnity insurance, as with all insurance, is it's a contract of the utmost good faith, and you have an ongoing duty to report to the insurer candidly about any matters that might affect their willingness or the terms on which they would provide cover. So you need to make sure that your insurers are kept updated about any situations that could potentially give rise to a claim, and keep them informed early on to ensure that you don't invalidate the insurance. Moving on to consider some of the questions around governance, I'm sure that in your organisations you already have established crisis teams leading at management level. And just to remember that you will also need to be keeping your trustee board updated and involved, which I'm sure you're all doing, in the context of facing quite rapid and serious and perhaps unexpected changes to the organisation's work. If you have a large board, then obviously you're not going to be able to keep all of the trustees closely involved in planning, and they won't be able to grapple with all of the detail quickly enough to reach quick decisions. So not all decisions can or should be made quickly, but in the situation that we're facing now, I think almost all organisations will find that they need to make some decisions very quickly. So you may need to think about liaising with a smaller subgroup of the trustees, and also arranging to have more frequent board meetings than you usually would. And to get the best decisions at those meetings, bearing in mind you're probably going to be having to hold them by telephone or video conference, it's particularly important to be presenting clear options and recommendations and reasoning to the board, and particularly when you're dealing with complex and fast-moving issues. And inevitably, the crisis team that you have will be closer to the detail and have more time to form opinions and to then steer that discussion. So the steps and the outcomes may appear more obvious to them and less so to some of the other trustees. And that can be an issue which is tricky for the chair and for the board to manage. And so do think about how you can best present the information to facilitate good decision making. Just a point for your trustees to remember as well, that while the charity is solvent, their duty is to act in the way that they consider in good faith would most likely further the purposes of the charity. In doing that, they're expected to act with reasonable care, skill and diligence, and they're not required to be perfect, and nor are you in the charity's management team. So in any situation, it may be the case that other people might make decisions differently from you. It might be, that there are different outcomes, but that doesn't mean that your decision is wrong. Or even if the decision turned out not to be the best decision in the circumstances, that the trustees have necessarily breached their duties. So it's important in this case to be making the best decisions that you can within the organisation based on the best information that you can get, and to be ready to explain why decisions have been made if you need to justify them later.
What the fuck are you doing?
It may be helpful in this case also just to remind yourselves of the Charity Commission's guidance on trustee decision making, which is on their website. It's called It's Your Decision, and particularly if you're thinking about recording trustee decisions, and that has a good framework for how to reach good decisions and what things to be thinking about, what records to keep to show that the trustees have acted responsibly in making decisions. But then to note that if the charity is either a company or a CIO and it is facing insolvency, be aware that the trustees' duties might change, and this then kind of cascades down to what should be the issue that the management are thinking about, which is that instead of seeking to achieve the purposes of the charity, the duty may switch to protecting the interests of the creditors. And I'll come on and talk a little bit more about that later on when I talk about wrongful trading. Another thing to be aware of is that the trustees still have duties to report serious incidents to the Charity Commission, and if you're registered in Scotland, to OSCR, the Office of the Scottish Charity Regulator, and you probably have an established process within your NGO for identifying serious incidents and for staff to draft reports for the trustee approval or to make those reports with delegated authority from trustees. And so a potential insolvency or serious risks to your organisation's beneficiaries, especially where they're vulnerable beneficiaries, is something that's likely to be reportable. And Bates Wells has put some guidance on its website in our coronavirus hub about reporting serious incidents in the current crisis situation. Another thing to be aware of is the importance of taking professional advice from lawyers and accountants, and particularly in a context where there's a risk that the charity may be facing insolvency. And that may be something that is particularly important in order to protect the trustees, and professional advisors may be able to help to save the organisation, but also protect the trustees from being held personally liable for being in breach of their duties. And Steve, I believe, is going to talk a bit later about the test for solvency and about how to approach crisis management from a financial perspective, including cash flow forecasting and considering a statement of affairs for the organisation. Another thing to think about at the moment is the question of your organisation's reserves. And obviously those are for a rainy day, and if they're for a rainy day, today is, despite the sunshine outside my window, metaphorically the middle of a hurricane, I think. So it's what your reserves are for. You can be bold in planning to use them, but you should also bear in mind that you may need them if the worst came to worst, to wind up the charity solvently if all else fails. And on a winding up like that, you need to bear in mind that the ratio of assets to liabilities might look very different. So it might not be possible to liquidate your assets quickly, and you might have debts like redundancy costs or pension liabilities which increase, and the assets might be less valuable if you have to sell them quickly to realise their value. Another thing to be thinking through is whether you're holding designated or restricted funds. So designated funds are funds that trustees themselves have chosen to set aside for a particular purpose. And they're different from restricted funds in that the trustees can decide to lift that designation and return the funds to the charity's general purposes. And something that we quite often find is that organisations are concerned about being able to use funds they think might be restricted. And on closer examination, they find they might be designated funds, and they're able to lift that designation and use the funds as general funds. You may also have assets which are held on separate trusts, which means they're held for specific purposes within the charity's purposes where you don't have so much discretion to change them. And you may have permanent endowment assets, which are those which can't be spent on the charity's purposes, where you have to invest the endowment assets and you can only apply the income, but you have to retain the capital. If you have restricted funds that are held as separate trusts, or if you have permanent endowment assets, then it's worth bearing in mind that under the Charities Act 2011, there are some powers that enable trustees to change and release restrictions and restricted funds, and in some cases to allow endowments to be spent. There are lots of conditions on these, and in many cases, unless they're small endowments, you might need the Charity Commission's consent. So it's not that you just have a blanket permission to go and make these kind of changes in a crisis, but there may be things that you can do in order to seek to lift restrictions or to vary the terms of trusts or permanent endowment. And it may be that you need to approach the Charity Commission about that. And the Charity Commission has been saying that its approach will be as flexible and pragmatic as possible at the moment. So again, if you have funds and you're looking at whether you might be able to access those funds or investments that are held on separate trusts or as permanent endowment assets, then do consider taking advice and exploring what the options may be there. And it may be that you have more flexibility than you expected. And it may be also where you have funds where the restriction has been put in place by an institutional donor or a grant-making trust or foundation, that they're also willing to be flexible in the current circumstances, many of them being obviously very supportive to the challenges that charities are facing. So I said I would talk a little bit about wrongful trading, and this is just something to be aware of in terms of what the board must not do if you're set up as a charitable company or a CIO. So your board would be potentially engaging in wrongful trading if they know, or they ought reasonably to know, that there's no reasonable prospect of avoiding the charitable company or CIO becoming insolvent and going into an insolvent liquidation. And if that happens, then at that point their duty switches, and it's no longer a duty to further the purposes of the charity. It becomes a duty to take all steps to protect the interests of the creditors. So it's very important to know wrongful trading liability is something which is often covered by your trustee indemnity insurance policy. So do check that and keep your insurers informed, and do take appropriate professional advice if you have questions about whether you might be anywhere near the point where there's no reasonable prospect of avoiding the organisation entering into an insolvent liquidation. The other thing that you need to be aware of is that you mustn't prefer one creditor over another when you face possible insolvency by paying one but not the other. And those payments can potentially be set aside by the court, and they can be grounds for board members to be disqualified from being company directors. So that doesn't mean you have to suddenly stop paying all the creditors or only pay them just a proportion of your debts. But so you could choose, for example, to pay a creditor whose continued support is crucial for the charity. And you can also pay for professional advice, but you need to be careful about the decisions that you're making. And finally, just to be aware that certain transactions, such as selling an asset for less than its market value, can also be set aside by the court in the case of an insolvency. So just moving on then finally to talk a little bit about how should you approach decision making. I'm going to focus on board meetings, but I'm aware that some of your organisations might also have annual general meetings coming up. So I'll talk briefly about that as well. I'd say at the moment that just to reassure your boards that making good decisions is more important than getting the process right at the moment. And certainly at a board level, you might have more flexibility than you think. And again, this is an area that we've put more detailed guidance about on the Coronavirus Hub that Bateswell has set up on its website. The charity's governing document, which is most likely your Article of Association or the Constitution if it's a CIO, will state how you can give notice of both board meetings and AGMs. And if it doesn't, then for a board meeting, you would just need to give reasonable notice. And that's going to depend on the circumstances, and in a particular crisis situation, it might be very short notice, it might be a matter of days or even hours. Even if you can't give the required amount of notice, then I would recommend that you call the meeting anyway if you need to make decisions, and think about how you can validate those decisions later. And when you give notice of the meeting, you need to be clear about what the matters are to be discussed, and the date and time and place of the meeting, and how trustees can join if they're joining remotely. In most cases, we would think that a board can hold video meetings, even if you don't have an express power to do that in the organisation's governing document. So there's legal authority that allows meetings to take place if the participants can both see and hear each other, which would happen on a video conference. And that would only really be overridden if there's something in the Constitution which expressly requires the board to meet in person, or says that they can't meet by video conference, which we wouldn't expect in most governing documents. So even if there isn't an express power to hold board meetings by video conference, you almost certainly can validly do that without that express power. You may also be able to hold meetings by telephone. There's a bit of a question there because the trustees would not be able to also see each other, but we think it's unlikely that in the current circumstances the validity of a telephone board meeting would be challenged. I'm happy to take more questions on that towards the end if you want a bit more detail on it. And then just to flag that it may be that you have a general power in the governing document that allows business or proceedings of the trustees to be conducted in whatever way they think fit, in which case you may not even need to call a formal meeting in order to be making decisions. Some alternative solutions, if you're not able to call a meeting, or if you call a meeting and you can't get enough people joining in for it to be quorate, would be to look at making decisions where the trustees all unanimously agree by whatever means, in which case that decision would be valid, however it's been taken. You may have an express power to make decisions in writing, either by a majority or unanimously. And if in doubt, you could just make a decision and then look to ratify it later if it's something that was an important decision of the so at a subsequent board meeting when you can hold them validly, look back over the decisions that have been made and ratify them and confirm them. It's also really important to be keeping good minutes, and even where you're acting to make decisions from day to day, and you may not be making formal decisions that engage your board, we'd say it's helpful to be keeping a diary of just the key decisions made day by day and the reasons for those, which can be very helpful if you're ever having to explain your actions at a later date. So if your charity also has a membership and you would be holding an annual general meeting for the members, that may also be coming up shortly, and you may need to be considering planning for AGMs. Again, we've put some specific guidance on this on our coronavirus hub, but some things to be aware of would be, first of all, to check the Articles of Association or the CIO Constitution about what it says about convening these meetings. You may well be able to hold them in a way that allows most people to participate remotely, and often we would call that a hybrid meeting, where you have at least 2 people in one place and others participating through a video link or potentially a phone link. Again, you need to think about whether everyone needs to be able to see and hear the proceedings or just hear the proceedings, and that may depend on what the Constitution says. But if it doesn't say anything, then if they can see and hear the proceedings, then you can go ahead and hold the meeting by video conference. The only issue, though, is that for a fully virtual meeting where you don't even have 2 of the members in the same place physically, you probably need to have express authority in the governing document to hold the meeting in that way. So you may need 2 people to be physically in the same place where the meeting is happening, and then the rest can join in a hybrid way through video conferencing. Another thing where I think a lot of organisations can get caught out is that if you've given formal notice to your members about the AGM, you can't then cancel or postpone or withdraw that notice. You can adjourn the meeting, but you won't be able to just change the notice or withdraw it. So if you would normally be planning for an AGM and giving your members a long notice period, say writing to them now about a date in September or October when you're planning to communicate the update on what the organisation's been doing over the last year, and you want to get the date in their diaries, do try to avoid giving them a formal notice and communicate with them informally about the tentative plans that you have for that meeting, and issue the formal notice as close to the deadline as you can. It's likely to be 14 or 21 days clear notice before the AGM takes place. But some organisations that have members overseas might have a much longer notice period. If, for example, you have member organisations overseas where they might want to be internally consulting on policy changes and then feeding back to an AGM. So just check if you have a longer notice period. But otherwise, think about not setting plans in stone too soon. That's about all I had to cover. So I don't know if Paul wants to come back or if I'm going to move on to Mindy, and we're available for questions towards the end. Thank you for listening.
Thanks very much, Stephanie. It's Mike here again from Bond. If anybody's got any questions, do please pop them in the box now and we'll ask them. I've actually got, I just wanted to sort of set the scene slightly in order to ask you a question, Stephanie, which is that yesterday we heard the Chancellor's announcement about £750 million of funding going to charities. It seems, well, I think we know from 99% certain it's not going to end up coming to international development charities, because it's for sort of frontline UK-focused services it's for hospices and so on. So that's one dynamic that's happening, that the funding offered to charities by the sector is very domestically focused. And then on the other hand, we've got donors like DFID who are interested in being flexible with organisations, but in a way on their terms around flexibility funding, pivoting programmes and so on. But it's highly likely that that kind of offer will be only available to people they fund already. By our calculations, we think there's just over 100 organisations within the bond membership who are funded by DFID. So that leaves about over 300 organisations who are neither receiving support funding from the Treasury, nor are going to get any benefits from an existing relationship with DFID. So it seems to me that there's high potential for insolvency across the ecosystem of our network. And I just wondered if that was filtering through to you, whether you were getting that sense that organisations were teetering on the edge. I mean, our own survey suggested that just over 50% of our members wouldn't be able to survive for 6 months of operation, given the reserves that they've got. I'd just be wondering if you, from the coalface, are you getting that kind of those kind of symptoms coming through to you?
Yeah, I mean, I think if you look at, say, some of the surveys that have been done across the UK charity sector as a whole, the percentage is similarly high of organisations that are concerned about their future survival. So yes, I think it is a very challenging picture if we don't get further support from government. And certainly the response of the sector to the announcements made yesterday evening were, well, it's a good start, but there are it's like you say, it's not very helpful for NGOs that are working outside of the UK, even though we know that the humanitarian response aspects of the COVID crisis and the need outside of the UK is even more than in the UK. So I think, yeah, it is just a very challenging situation that a lot of organisations are facing, and hopefully we will see more government support, but it is particularly difficult. I think the other thing is that a lot of organisations are finding that with fundraising events being cancelled and things, that they've had to put a lot of their fundraising teams onto furlough, and so their ability to generate income is also severely constrained. I don't know if Steve might have more perspectives on organisations that he's been in touch with.
Yeah, I think I'd really echo all of that in terms of a lot of organisations are having to consider what the worst case scenario might be, and in particular it is difficult, very, very difficult in some cases to raise funding, given a lot of the avenues to raise funding have now been removed in terms of fundraising events. What I've also heard of is some cases of trusts and foundations, understandably perhaps, diverting previously advertised funding rounds towards COVID-19 related projects, which is absolutely understandable, but at the same time, for those organisations that were perhaps relying on that as an avenue for fundraising, it again further diminishes the available options. So yeah, I'd really echo that, and certainly seeing it across the sector. But I think international organisations, I think, are finding it particularly challenging, especially where there isn't a direct link or a potential direct link in COVID-19 to the work that those organisations are doing.
Yeah. Thank you. I've got a question here from Caroline Ford, who asks, can you say something about restricted funds? Could we use them to pay salaries if necessary and replenish them in the same financial year?
So I think the question with restricted funds is a very tricky one, because restricted funds essentially are an accounting concept, and the underlying legal concept that relates to them is trust law. But a fund which is treated as a restricted fund for accounting purposes may or may not amount to a separate trust within the charity, and that is probably going to affect whether you are able to use the restricted funds in the way that you describe without the trustees being in breach of their duties. So particularly if you are facing a potential insolvency, broadly speaking, the restricted funds that are not separate trusts will become available to discharge creditors, whereas funds that are held on separate trusts actually are not part of the corporate property of the charity, and so may not become available to the creditors and may still have to be applied in accordance with the terms of the trusts. And the question of whether the restricted funds are held on separate trusts or not can be legally quite complicated, and it's going to depend on how that restriction has been established, and whether it's a matter of a contractual agreement or whether there's some kind of express or implied trust. So one thing would be to look at where that restriction is coming from. The other thing to be aware of is that I think it's quite common actually for charities to dip into restricted funds with the expectation they're going to pay them back from another pot of money within the year. But it's a very risky approach, because if those restrictions do apply to trusts, or if they are a matter of contract, the trustees might find that they're in breach of trust or in breach of the contract if they're not able to replenish those funds. And at the moment, when the wider situation is so volatile, it's quite hard to be sure that you actually can replenish funds in that way. So I would be very nervous about doing that and caution against it, notwithstanding that I think it is something which actually does happen quite commonly in charities. If you're thinking about trying to lift the restrictions, one thing may be to have a conversation with the donor or the institution or trust or foundation that has provided the funds and see if they're willing to be flexible. And another may be to look at what is the source of that restriction as well. So, is it some money you were left in a will a long period, a long time ago, or is it a current, restriction imposed by a current grant funder, or is it something else? Because it may be that you have different levels of flexibility depending on what the restriction is. And it may be that actually what you have is, like I said, not actually restricted funds, but designated funds. And if it's designated funds, then the trustees can lift that designation themselves and use the funds for anything within the charity's purposes.
And just a slight correction, I got Caroline's phrase wrong. It's actually, she used the phrase restricted reserves, but does that amount to the same thing, Stephanie, or is that a different question?
I suppose the question is whether you're talking about what you mean by restricted there. So if you're talking about the reserves of the charity that have been set aside for a rainy day, then probably yes, you can use them. If you're talking about the reserves that have been restricted for a particular purpose within the charitable purposes of the organisation, so for example by a donor, or if it's an endowment where you were given a gift under a will and you were only able to spend the income and not the capital, then that would be permanent endowment. So it's going to depend on what you mean by restricted reserves.
Okay, that's great, thank you. I don't think we've got any more questions, so we'll go. I think at this point we're going to go back to Paul, if you're ready to come back. Thanks so much, Stephanie, and if you can stay around and just take any more questions later on, that'd be great. Paul.
Hello, can you hear me any better now?
Yes, that sounds better.
Good enough to carry on, or should I continue trying to fix the problem? But I think that's all I can probably do. So what I'm going to do then, I'm going to go to the share screen and hopefully get my slides up. So just give me 1 second to do that. Right, we've gone back to the beginning, but can somebody let me know that they can see that okay and they can hear me?
Yes, we can see and hear you.
Okay, now we know why Ant and Dec get paid so well for the work they do live on screen and on television. So,
Oh, you dropped out a bit again.
Sorry?
You went a bit lower then as well.
Okay, well, if I'm going to talk about the coronavirus job retention scheme, and this is more just a test to make sure that people can hear me, I'm not going to recap on everything I've said, so I'm going to scoot through to where we had got to, and then pick up from there. If I do that, and if the audio is as it is now, is that going to be okay, Lena?
Yes, you sound, don't move, you sound perfect there.
Okay, I can't promise not to move, so jump in if it fades out. So just going through then to where we had got to. We talked about what employees are covered.
You've gone a little low again.
I haven't moved, so I think we're going to have to abandon my slot because it's incredibly frustrating for people listening, and we'll have to
Do you maybe want to just test your speaker and microphone in the bottom left-hand corner?
Okay, shall I do that offline? Because I'm just conscious that everyone...
Yes, and we can go to Mindy.
Yeah, that's fine. I'm happy to do that. Okay, good afternoon, everyone. Let me just pull up my slides so that you can see them as well. Okay, right. So what I want to speak to you about this afternoon is a bit more of a drilling into the detail of what we've already discussed in terms of financial planning, because I want to talk to you about the effect of coronavirus on your contracts and your contractual obligations, which might mean an obligation to deliver something that you're now struggling to think how you might do that, or an obligation to pay something that you might prefer to get out of. Or it might be that you've got some sort of event or obligation coming up that you're not sure at this stage that you'll be able to deliver. And so I just want to think through what that might look like. So the kinds of questions we've been getting from clients are things like, I've entered into a contract to do some sort of fundraising event, and I don't think I can do that anymore. So what are my rights legally? What's my position under the contract, and what are my options? Or it might be that you've promised under a contract to deliver some services and you're no longer clear about whether you'll be able to do that. So that's the sort of general framework. So events, things like fundraising events or conferences, or sort of general delivery of contractual services. So before we dive into the detail on it, I want you to kind of take a step back and think about the key contractual obligations that you've got coming up within the next few weeks and months. And I want you to think about exactly what your contract says. I mean, pull it out, dust it off, and have a look at the obligations that are contained in the contract, and think about exactly what it is that each party has promised to do. And the reason I say that is because a lot of this turns on the detail of what is contained in the contract. And so the starting point is to think about, under the sort of black and white letter of this contract, what does the agreement say that each of the parties will do? What does it say about how they'll do it, who will do it, in what circumstances, when? I mean, when is likely to be a key question that comes up, but just sort of really basic, if you had to give an 8-year-old an explanation of how this contract works, what would you say about who was doing what, when they were going to do it, and who was going to pay what and how much and when? Okay. then you can start to think about what the contract says about your rights in any event. So regardless of everything that's going on at the moment, what does the contract say your rights would be to cancel it, to bring it to an end, to terminate it, just in ordinary circumstances? Some contracts will say that you have to have a reason for doing that, like a breach, for example, on the part of the other party, whereas some contracts will just give you a right to terminate for what we call no fault. So you can just simply give notice of, a month or 3 months or however long it is. So thinking in the first instance about what your obligations are and precisely what they are, and then what rights the contract gives you just generally, is going to be a really good starting point for thinking about where you go with it next. But the questions we've been asked are, is there anything specific that can help us in these really quite unusual circumstances? And so what I want to talk to you about this concept, firstly, of force majeure. So this is a legal term that comes up sort of quite rarely, but obviously over the past month or so you've been hearing it a lot more. And force majeure is a provision that will be contained within the contract that you may be able to rely on. So there's no general definition of force majeure in law, and it doesn't apply unless your contract says it does. So quite often in a contract you'll see a clause with a heading that says force majeure, but not necessarily. What you're looking for in your contract is any clause that talks about some sort of circumstances beyond the reasonable control of the parties, and it may even use that exact wording. So when you're thinking about what a force majeure event is for the purposes of your contract, you have to look to the contract to specify the definition. So the contract might say something like, it might make the express reference to things like war or a natural disaster or even disease. They often talk about acts of God, which can include big things like earthquakes or floods, or classic example of force majeure is the volcanic ash cloud that caused travel chaos back in 2010. But really in these circumstances, so what you're looking for is anything that specifically talks about pandemic or even epidemic, and then thinking a bit more broadly and coming back to this question about your contractual obligations and what they were, what you're trying to think about is what is the event that's causing the issue here. So usually when we talk about pandemic or epidemic, we're talking about the fact that there is a disease, there's a prospect that people may become ill from the disease, and that is what would impact on your contractual obligations. Actually, what I think we're probably talking about in most cases at the moment is not the pandemic itself, but the associated restrictions. So it is the fact that the government has imposed restrictions on people travelling and on people gathering together for all but the most specific circumstances that is causing the issue with, for example, holding a conference or an event or something like that. So when you look to your force majeure clause, you want to be thinking about what is actually causing the issue here, and is that covered by your clause? So sometimes clauses will refer specifically to any action taken by government or any law passed or something like that, which would cover the restrictions, but it might just talk more broadly about circumstances beyond the reasonable control of the parties, and that's the kind of thing that you're going to be interested in looking for. So if you've got that in your contract and you think you fall within the definition, what happens next? What you have to do is show that there's a causal link between the force majeure event and the delay or the failure to perform. So you have to show that it's as a result of the pandemic or of the restrictions that you can't do what you promised to do. And I just want to pause there and think about stepping outside of the black and white letter of the law of your contract and think about a bit more creatively about whether there's some sort of alternative arrangement you can come to. So if, for example, the thing you'd promised to do was to attend a conference and deliver a speech in person, clearly it's not possible to do that anymore, but an obvious alternative is to have a webinar like this one. So just thinking about what you've promised to do. So again, going back to that very first question that we asked ourselves, what are our obligations, or what's the other party's obligations, and thinking about whether you could reach an agreement with them to do it differently. So in substance, you're kind of delivering what you said you would do, it's just that you're performing it in a different way, a way that is possible in these current very unusual circumstances. So, okay, so if you've gone through that sort of process, but you think that actually it's not possible to do what you said you would do in a different way, then you have to look to the contract to specify what the effect of the force majeure clause is, because the contract will tell you that. And what it will normally say is that the parties are excused from the performance of their obligations until the force majeure event comes to an end. So, that also raises additional questions, because what do we mean by the force majeure event coming to an end? We have to go back to one of the early questions we asked, which is, well, what is the force majeure event? If what we're talking about is the restrictions that have been imposed by government, well, that followed a certain timeline, didn't it? So first they said, we strongly recommend that you social distance and that you don't travel or work unless it's absolutely essential, but it wasn't, they hadn't laid it down in the law. But then quite soon after that, you did get the Coronavirus Act and the restrictions that said you actually can't leave your house unless there are specific, very clear exceptions. So when you're thinking about the fact that your force majeure event might come to an end, what do you actually mean by that? So you're going to have to reach agreement with the other party on that, because if the government were to lift the restrictions tomorrow, I mean, they won't, it would be nice, but they won't. But at whatever point they do decide to lift the restrictions, what happens if they say, actually, we still strongly recommend that you follow these rules, even though we're not going to insist that you do that anymore? What happens then in terms of your contract? Does it just bounce back to the original obligations, or do you have some sort of tapering effect? So to give you a really silly example, like what if your obligation was to deliver a bus timetable? And you've decided with the other party that you can't deliver the full timetable anymore because of everything that's going on. What happens if tomorrow the restrictions are lifted, but your passenger numbers obviously are not going to bounce back to what they were before this all happened? Are you going to be obliged then to deliver the whole full timetable again, or are you going to agree with the other party that there's some sort of tapering effect where you gradually expand the services over a period of time, so that you then get back up to what you originally promised to perform? These are the kind of practical details that you're going to need to think through if this clause applies. And the point is that the clause can obviously not be specific about how it's going to apply, because it's anticipating a number of different types of events. And so the bottom line is, it is about opening a discussion with the other party or parties to the contract and trying to hammer out how this is actually going to work in practice. So what we're doing here is we're using the letter of the law, the kind of legal contractual provisions we might want to rely on as a starting point for trying to get a deal done, basically. Okay, so that's force majeure. The other thing I want to tell you about is relevant where your contract doesn't have a force majeure clause, or maybe it does, but it just doesn't apply for whatever reason. Actually, on that note, I have seen force majeure clauses that are quite specific about who can rely on them. So they might say that if a force majeure event happens, that only one of the parties can rely on the clause to effect a suspension or even a cancellation or whatever it is. And that is tricky if you're not the party that's in the driving seat. But what the courts tend to say is that the reason you have contractual provisions is so that the parties can allocate the risk associated with entering into the contract. So if the force majeure clause only gives rights to one of the parties, the court is likely to say, well, actually that's what you agreed, and that is how the contract allocates risk. So again, just something to bear in mind. And again, that doesn't mean you can't agree something different with the other party. It just means that probably they're a bit more on the front foot when it comes to having those discussions than you are. Okay, so let's move on. Frustration of contract might apply in circumstances where you can't rely on a force majeure clause. And what we're talking about here is a situation in which something happens which makes it impossible to perform the obligations under a contract. So that includes, as a subset of impossibility, a change in the law, for example. So now that we've got these restrictions in place, is it now actually illegal for you to perform what you said you would do? So if, for example, you had been planning to host a conference today, a sort of real live in-person conference, it's arguable that that contract has been frustrated by the fact that people simply cannot attend a conference like that. So you might be able to rely on the doctrine there. Again, there's this point about what happens if it's not illegal, if it's just sort of strong recommendations and guidance from government. Well, in that case, I think you probably wouldn't be able to rely on the doctrine of frustration to help you, because it's quite narrowly drawn and it's quite exceptional. It doesn't really apply in very many circumstances. There are two other things to think about when you're thinking about whether this might apply. And the first is pinning down exactly what your obligations are and how they've been affected. So that again takes us back to the very first question I asked you to think about, which is what are the contractual obligations? And there's a couple of cases that illustrate this really well. So one was about a contract for the supply of potatoes from a farm, and the contract was very specific about where the potatoes were to be supplied from. They were to be supplied from that particular farm. And so when it became impossible to supply the potatoes because of a disease that affected the crop on that farm, the contract was frustrated because the obligation that had been entered into simply couldn't be performed anymore. It was impossible to perform the obligation. And then there's another contrasting case. This is actually a US case, but it still illustrates the point very well. Was another farmer who'd agreed to supply milk, so a commercial milk supply contract. And this farmer's farm was quarantined because of foot and mouth disease, and unfortunately all the cattle had to be destroyed. And so the farmer, quite obviously, I guess, tried to argue that, well, you know, the contract has been frustrated because I can't obviously do what I promised to do. I've got no cattle left. But when you looked at the actual obligations under the contract and the way that they had been drawn up, it did not say anywhere that the milk had to be supplied from that particular farm, from those particular cattle. So in theory, the farmer could still have performed his obligation to supply the milk, but it's just that he would have had to go elsewhere and perhaps, you know, obtain it from a third party and supply it on, which clearly wasn't what he had intended to do and might have been a whole lot more impracticable and probably much more expensive. But those things didn't mean that the contract was impossible to perform in terms of the specific obligation and the way that it was drawn. So we have to be really, really careful about what the obligations are and whether they have in fact been frustrated, depending on how the contract is drawn. And the important thing to note there is that just because a contract is no longer commercially attractive, or because one or both of the parties are worried about their cash flow or their financial position, doesn't necessarily mean that it's impossible to perform. It might just mean, in sort of strict contractual terms, that it's less desirable to perform it. And that's actually two quite different things as far as the law is concerned. The other thing I wanted to mention about frustration and what to factor in is the timescale of your obligations. So there's a couple of cases on this as well. One is to do with somebody who was providing transport services to a school, and the school got closed down actually because of a flu outbreak, and it was closed down for a period of a month. But the contract to supply the transport services was an 8.5-month contract, so it must have been aligned to the school year or something like that. And the court held that actually, yes, okay, the school was closed for a month, but that didn't mean the transport supplier couldn't actually deliver the services. I mean, they still had access to the fleet and could still deploy it. And also in the context of an agreement that was designed to last 8.5 months, a 1-month closure wasn't significant in the grand scheme of things. And there's another case which took place during the SARS outbreak, and this is a Hong Kong case where someone was prevented from reaching their flat due to an isolation order being imposed, and the isolation order was for 10 days. And the person said, well, I can't get to my flat, so I can't reasonably, enjoy the benefit of what I've contracted for under my tenancy agreement. So the contract must be frustrated then. And again, the court held no, because 10 days in the grand scheme of a much longer contract for a tenancy doesn't equal frustration. So again, we have to think quite carefully about the timescale that our obligations are to be performed to. So how might that work? If you've got, I already mentioned that if you've got an event that was supposed to be taking place sort of now within the next week or so, I think you've got a fairly strong argument that that's been frustrated because it's impossible to perform because of the government restrictions making it unlawful, basically. But what happens if your conference is due to take place in 6 months' time? What happens then? And that's a more difficult question, because these restrictions are in place until further notice, and we don't know at the moment when that notice is going to be given. So I would say that as of right now, it's probably quite difficult to argue that your contract has been frustrated if your event isn't taking place, within the immediate future. But it's something that you're going to want to keep under review, because of course, as things rumble on and you get closer to the date of the event, then that might become relevant. What else was I going to tell you about that? Yeah, if you're, and then the other point is that obligations that are ongoing. So yeah, if you've got a longer contract like the school transport one or the tenancy one, where actually the promises you've made are to be carried out over a longer period of time, you have to think about whether you have actually been hindered from performing for a sufficiently long period of time for this to bite. Okay, so why are we talking about frustration? What's the effect if it does actually apply? Well, what it means is that the contract is dissolved. So it's treated as no longer being in effect, and actually as kind of never having existed. So that means you don't have to perform any future obligations under it. And also, if you have started paying money under it because it was some sort of instalment payment plan or something like that, you are able to recover the monies that you've paid to date. The only exception to that is where the other party has incurred reasonable expenses. So to illustrate that, the original case where this doctrine comes from is about a contract for the hire of a music hall. So the owner said to the hirer, you can use this music hall for 4 days. And in between the contract being signed and the dates of the performances, unfortunately, the music hall burned down. And so what happened was that the hirer tried to sue the owner because they said, look, you promised to deliver a venue to me and you haven't done it, and I've incurred losses as a result. You must be responsible for those losses because you haven't delivered on your contractual promise. And ordinarily that would have worked, but what the court held was that in these very specific circumstances, it was in fact impossible for the defendant to do what they had promised to do because the music hall had burned down, it no longer existed. So actually what the court did there was to reallocate the risk in the contract and to say that in these very exceptional circumstances, sorry hirer, you haven't got what you bargained for, but actually the circumstances are so unusual, it was clearly impossible for this poor defendant to perform what they said they'd do, that we're going to treat the contract as being at an end. Now, if the hirer had in addition promised to repaint the venue, for example, before the hire date, and they had actually done that repainting before the hall was destroyed, they could actually have claimed for the reasonable expenses associated with doing the repainting, because what they will say is that, we had to buy paint and we had to pay people to paint the place, and the only reason we had to do that was because we promised we'd do that under the contract. So although this contract is now going to be sort of torn up and treated as if it had never existed, actually that's a bit of a legal fiction, because we have all been performing under this contract as if it did exist. And if we have been doing that and we have incurred expenses reasonably in association with what we promised to do, then we can have those back. Okay, so the reason I'm talking to you about force majeure and frustration is because these are legal concepts that might help you when it comes to having a discussion with the other contractual parties. Of course, you can, if your position is strong, rely on those concepts at court. So, you know, you might want to bring a claim, or you may unfortunately find yourself defending a claim. But I think what's probably going to be more likely, in the short term at least, is that people are going to be trying to reach agreement with each other, because of course everyone's in the same situation. And so there are certain things you'll want to be factoring into those discussions. First is obviously what the legal position is and whether you've got strong arguments you can make based on force majeure or frustration, or even just the ordinary termination provisions in the contract. Then, of course, you want to factor in the fact that these are really extraordinary circumstances, that the position is very unclear, that we know what we know about the legal principles and how the court has applied them in the past, but actually what we don't really know at this stage is how a court might apply them in the future, with reference to what's happening right now. So there obviously is some litigation risk associated with playing hardball and saying, well, I'm just going to rely on the letter of the law. And the other really key thing to factor into those discussions is having half an eye on the future. So, you know, I've put a lovely picture of a rainbow on the slide there, because I'm thinking about someday over the rainbow, when hopefully we might be looking to get back to normal and be resurrecting the relationships, the contractual relationships we've got. And with half an eye on those future relationships in a kind of post-pandemic world, we might, or the other party might, be inclined to make some concessions, regardless of what the strict letter of the law entitles them or entitles you to do. What I would say there is I'm seeing some situations where people have sort of panicked slightly and jumped the gun, and they've purported to terminate when, you know, on a strict analysis, they probably didn't have the right to do that. And so I think what you want to be thinking about there is protecting yourself when you enter into those negotiations, and thinking about the fact that, yeah, you're probably going to end up making some concessions, but you have to think very carefully about whether you want to do those on an open basis or without prejudice basis. So, for example, if the other party has purported to terminate when it didn't have the right to, that might put you in quite a strong legal position, because you could sue them for breach of contract, basically, and any associated losses. But you might not want to do that for various reasons associated with your relationship, the fact that we're all in extraordinary times, and so on. But if you do make concessions, you probably don't want to do that on an open basis, because you might want to reserve the right to bring the agreement to an end and claim those losses if you can't reach agreement. So you have to think quite carefully about whether you want the discussions to be that you're having to be on an open basis or an off the record basis, which we call without prejudice in legal terms. So, okay, that was a little whiz through the contractual principles of frustration and force majeure, but also the more general contractual principles and the key contract terms, and then sort of getting you to think about how you might apply them and how you might use them to your advantage in your discussions with the other parties to your key contracts. Just want to move on very briefly, because Stephanie's already spoken about this in the context of trustee decision making, but although it might be the last thing on your mind right now, if you're talking about significant financial losses, or even the risk of significant financial losses, that is going to be a serious incident that's potentially that is reportable to the Charity Commission. And the Commission put out specific guidance in response to the pandemic, and said that actually it does expect that charities should continue to report serious incidents. They should still have regard to the current guidelines and use their own judgment, and they'll let you know if they decide to suspend the serious incident reporting regime, but actually they haven't done that yet. I think probably part of the reason for that is, although you've probably got every single charity thinking about reporting on these grounds at the moment, the Commission uses the information that it gathers from serious incident reporting to build up a picture of what's going on across the sector. So it's part of its regulatory obligations is to keep an eye on the sector, and also of course to keep an eye on whether it thinks that trustees are managing and responding to events appropriately as well, seeking to mitigate losses where appropriate, and that sort of thing. So just to recap then, a serious incident is an adverse event which results in or risks significant harm to your staff, operations, finances or reputation. And under the heading of operations, I think I would also say that it's to do with whether you can deliver your services and whether you can offer the help you're supposed to be offering to your beneficiaries. So if you have a concern that actually your activities are likely to be severely curtailed as a result of what's going on, then again, that's something that is reportable. The final thing I want to tell you about before we move on to another speaker is about insurance. So Stephanie again mentioned this in the context of trustee indemnity insurance. What I'm thinking about is more like sort of business interruption type insurance, and whether you can make a claim on that. And I'd love to be able to tell you that the position is really black and white and clear, but unfortunately it's uncertain. It's very unlikely that COVID-19 is a specified event in your insurance policy that means you can claim for compensation associated with the impact of that. But, you know, it all is going to turn on the wording of exactly what your contract says. So again, the starting point is to get your policy out and have a look at it. And when I say contract, I mean obviously the policy, and think about what the definitions in that are and the circumstances in which you can apply. And the other thing that I would echo that Stephanie said is about notification, because these policies often have as a condition of claiming a clause that says you have to notify the insurer as soon as possible. So yeah, the message there is to have a look at your policy, think about whether on the face of the wording it may apply or arguably could apply, and then open discussions with your insurer by notifying them. Okay, that's me on contracts and negotiations and related matters. Does anyone have any questions now?
Hi, Mindy. I don't think we've had any specific questions coming through, unless anybody wants to ask something at this point. Yeah, I mean, it's clear from what you're saying that people, you know, don't make precipitate decisions, negotiate, renegotiate, go back to the original contract, make sure there's being clear on the terms, particularly like the thing that you raised about the resuming your bus timetable. And I think that's what lots of organisations will be discovering, that once they're out of the COVID period, it may not be possible to sort of resume full service at that point. So yeah, I think those are really, really good points. And thank you, Mindy. I think we're going to move back to Paul again, because I think there's lots of questions about the furlough, and Lena's managed to set something up which will hopefully work this time.
Hi, can you hear me?
We can hear you, yeah. Paul, are you okay to share your screen?
Yep, no, I'll go and do that now. So, share screen. Is the sound going to work, do you think?
It is, you sound great.
Grand, okay. So, I am, let's make that, so hopefully, so we go back to the beginning, and we'll go from the top, we'll rattle through it. Okay, so is that okay, Lena? Are you seeing that all right?
Perfect.
Yeah. Grand. Okay, well, look, so sorry about that, third time lucky. I'm going to start from the beginning. I understand that a few people joined after I had started before, and you're the benefit of the technical difficulties, because I had to cut it short and return to it now on a different system. So the coronavirus job retention scheme, hugely important, and lots of queries and questions about it. Hopefully by the end of the session, some of the questions that you may have in your mind will have been answered, but if not, then we'll attempt to pick them up. But also, I may well be repeating stuff that you are already aware of, and if that's the case, then apologies, but I'm just trying to cover it from top to toe so that everybody is on the same page. So, which employees are eligible for reimbursement? All UK employers are eligible for reimbursement. There are three key criteria that you'll need to meet, and the third of which is brand new, and so it is one that you should be getting on with. PAYE payroll scheme needs to be in place from the 28th of February. So you can obviously check that that's the case, and will be. You've got to have a UK bank account, and that's where the money is going to go. And you've got to enroll for PAYE online, which can take up to 10 days. So make sure that you are enrolled for PAYE online, and get that done, because you don't want that to delay your claim, or certainly the getting of the money which you will be seeking. And in that regard, I've heard today that the intention is for the online portal to be up and running by the 20th of April, which is great news. And two things flow from that. One is we can put our claims in, and I think I read that they are hoping to have payments made by, or the first payments made by the 30th of April, so that's good news. But also it may give us more information about some of the uncertainties we've got around the scheme, in terms of who can claim for what, in terms of any questions that might be posed by the system that you'll need to complete when you are putting your claim in. So we'll await for that to come out online. We talked about public funding. I'm going to just sort of run through that again. And the point from the guidance is that the government expects that the scheme will not be used by public sector organisations. They consider that the majority of those organisations will either be providing essential public services or will be contributing to the coronavirus response. And where they do receive public funding, which they are, and that funding is continuing, then those organisations are expected to continue employing their staff. And I think that's going to apply whether those staff have actually got anything that they can realistically be doing or not. And the rationale for that's clear. It's that there's no point in having one set of public money and being replaced by another set of public money. So that we can understand that. But because it applies to non-public sector employers who receive public funding, it's caused some concern. And in that regard, we look to the guidance, and the guidance has one paragraph that deals with this. And it says, and it's on the slide, in a small number of cases, and I think the intention there is that it's small in terms of the overall UK economy rather than actually small in number. And it gives an example. So presumably there are other examples that one could think of, where organisations are not primarily funded by the government and whose staff cannot be redeployed to assist with the response, the scheme may be appropriate. So that is the guidance position on those organisations that receive public funding. And it tends to suggest, doesn't it, that where the employing organisation, or you, is not wholly or mainly funded by public money, and if your staff cannot be redeployed to assist with the effort, then you may in principle access the scheme. I mean, I would take the view that another example would be that where you're not wholly or mainly funded by public money, and whether or not your staff can be redeployed or not, if you haven't got the funds to pay them, then you ought to be able to access the scheme. And I think a view that's a reasonable view to take, but again, we don't know how HMRC will eventually look at it, but I think it's difficult to see that a private sector employer or charity who contracts to provide services to public bodies can be said to be receiving public funding for its staff costs, which is the wording in the guidance, unless there is a direct correlation between payment for the services and the staff costs. So that is the starting point, it seems to me, for any consideration around a public funding question, and one would want to go through a systematic review of your funding and satisfy yourselves that you you come within the scheme. And if you need to speak to your advisors about that and record that thought process, then that would be well worth doing. So what employees are covered, they have to have been with you and on your payroll system on or before the 28th of February. So anyone hired after that date or going onto your payroll system after that date, they cannot be furloughed. And that's caused some angst in media, but there are unfortunately a group of people who have been shifting jobs at that point or around the February time, and they are therefore losing out and won't be furloughed. The rationale for that was simply anti-avoidance, I think, because if they had announced the scheme and then run the date from, say, the 28th of March, between the 30th of March when the scheme was announced and the 28th of March, you would be surprised how many people would have been employed by various businesses around the country, families and friends and cats and dogs and all sorts, and then claims would be made for those supposedly then furloughed staff. So it was anti-fraud mechanism. I think the 28th of February was a date that was just convenient for HMRC. It was an end of the month, so but that leaves them very vulnerable and very exposed. And the government's legislative agenda over the last 12 months and looking ahead to the following couple of years is to protect and enhance the rights of those vulnerable workers. So do give some careful thought to including them in your furlough plans, because they are desperately in need of the money as well. Foreign nationals are eligible to be furloughed, but a key theme throughout the guidance is that to be eligible for furlough, you are not allowed as an employee to undertake work for or on behalf of the organisation, including providing services or generating revenue. So bear that in mind, it's critical, and any work that's done could completely compromise the furlough claim. And it goes in view on a literal reading. Providing services is anything that the individual might do, answering queries or just pointing you in the right direction of something that you need to find on the system. So just be cautious about that. How it will be policed and monitored is another thing, but just be aware that that is what the regulations, or at least the guidance, we haven't seen any regulations yet, but the guidance says. Employees who have been made redundant already, but who stopped working on or after the 28th of February, they can be re-employed and they can be put on furlough. Employees on reduced hours, and now the slide here says cannot be furloughed, and what we're saying there is, and it's an important point just to stress, is that if somebody's on reduced hours and therefore on reduced pay, they can't be furloughed while they are doing those reduced hours because they are not allowed to work. However, if you have somebody on reduced hours, you would be able to furlough them as long as they stop working. And obviously those individuals would want to agree to, first of all, go back onto their full hours, the hours applicable before you agreed the reduction, and then be furloughed from that so that they get the 80% of their actual income pre-reduction. Employees on sick leave or who are self-isolating, they get SSP, they do not get furlough. Once they return from sick leave or from self-isolation, then they can get furloughed. That's going to perhaps cause some issues around staff who have been on long-term sick leave for a considerable length of time before all this became the situation that it is now, saying, I'd like to come back, please, and be furloughed. And we'll need to take a view on a case-by-case basis if that's going to be appropriate, because the scheme is aimed at organisations and problems arising from the coronavirus outbreak. And those issues around the long-term sick employee may not be made worse by this particular crisis. So just think about that and consider it with your advisors. Employees who are shielding in line with public health guidance, or who need to stay at home with someone who is shielding, are able to be furloughed. But what the new guidance that was published on Saturday last says, and this is new, it wasn't in the previous iterations of the guidance, is that they first of all have to be unable to work from home. So that's the first hurdle that you'll need to clear. And also the guidance says, and would otherwise be made redundant. And this is the only part of the guidance that seems to impose a requirement that that particular category of people, the shielding employees, would otherwise be made redundant. It's not something that seems to apply to anyone else that you might be claiming for. So why that's in there and how it's come to be in there, I don't know. It may not be intentional. It may just be something that hasn't been thought through in as much detail as one would like. But it is an extra hurdle that you'll need to bear in mind for those shielding employees. And also, I would stress that they've got to be shielding in line with public health guidance. So make sure that you are satisfied that guidance is applicable because you don't want to come unstuck later and find you can't claim for it. The guidance goes on to have another section on employees who are unable to work because they have caring responsibilities resulting from COVID-19, and they can be furloughed, and the example given is employees that need to look after children. No requirement that they need to be at risk of redundancy. No requirement that they are not able to do their work at home. So that is clear from the guidance, but may well lead to some staffing morale issues if people on or without those responsibilities are not furloughed, and those who have that responsibility are furloughed, and there might be some resentments and so on that you'll need to tackle and manage practically on the ground. And because don't forget, you're going to want all of these people when they come back after this, or after we return to the new normal, you'll want them to be sufficiently engaged. So there's a people piece around that as well. Employees with more than one job can be furloughed from each job, and if somebody is furloughed from one, they can go and get a job with someone else. How that's going to apply if an individual has two jobs for you, we don't know. It's unclear, but the guidance can be argued in either way. So if that is a specific issue where you have an individual with two contracts doing two different things for you, then reach out to us or your advisors, and let's talk it through and just work out if it's going to be a claim or not, and what the risks associated with that might be. Employees on fixed-term contracts can be furloughed, and their contracts can be renewed or extended during the furlough period without breaking the terms of the scheme. So again, there might be some fixed-term contracts that were going to come to an end anyway, and the work has been done. You may not necessarily be in the mind to extend those just to keep them on furlough. But if somebody's fixed-term role hasn't concluded or would have been extended but for COVID, or has been extended because of COVID in the sense that they couldn't finish the job, but you want them to do so, then they are in frame and eligible for furloughing. I've touched on this, but does the employee have to be at risk of redundancy to be covered by the scheme? And now, I think the answer to that is no, apart from those who are shielding. The scheme talks about, and this is some quotes from the guidance, if you cannot maintain your current workforce because your operations have been severely affected. So you may technically not have a redundancy in the sense that work still needs to be done. It just that it can't be done, or that you haven't got the money from other sources to pay for it. And it's designed to help employers whose operations have been severely affected to retain their employees. So I think it's a pretty broad brush approach that's been taken by the guidance, and the previous guidance talked about either redundancy or being laid off, which is one sort of step below redundancy, if you like, in the sense that the contract continues. So no absolute requirement to prove, I don't think, that this person would otherwise have been made redundant. I don't think that's going to be something that we're going to have to do. And it seems unlikely that HMRC will take a forensic analysis of the circumstances at the point of claim. We understand that trade unions have sort of looked favourably at the scheme, and we're hoping that unions will embrace your decisions to do it and give you some pressure to do it indeed. But the government retains the right to retrospectively audit all aspects of the scheme within scope and claw back fraudulent or erroneous claims. And the records that you've got to keep, which I'll touch on in a moment, have to be kept for 5 years. So the revenue may be thinking that it's going to take 5 years to get through all of the auditing processes that they need to go through. So even if you get the money, there still may well be questions later, and therefore clawback if claims have been made when they should have been. And that's just something that we'll have to factor into our sort of thinking around do we or don't we furlough now. I've been advising clients on some of those issues. If your employee does volunteer work, what happens there? And the guidance says that a furloughed employee can take part in volunteer work if it does not provide services to or generate revenue for or on behalf of your organisation. So that suggests that people can volunteer for your organisation. I mean, it's clear that they can volunteer for other organisations. That's never been in doubt. But the guidance sort of opens the door to volunteering for your organisation. And it goes on to say that your organisation can agree to find furloughed employees new work or volunteering opportunities whilst on furlough, if this is in line with public health guidance. But it's still unclear. I mean, because it still says that when you are furloughed, you are not allowed to provide services to your employer. So query, whatever it is they might be volunteering to do, is that providing services to you? And that will need to be thought about on a case-by-case basis, it seems to me. But any work that they might do which is akin to what they would have been doing if they were at work, or what somebody else would have been paid to do, then I think that's probably going to fall the wrong side of the line and therefore put at risk the claim that you might later make. So just bear that in mind around the volunteering piece. You can, though, have people training while on furlough leave, and it's to be encouraged, in fact. But it's important that the training doesn't also constitute services or generate revenue. So if it's on-the-job training, then that's not going to be something which is possible under the scheme. But if it's simply training and pure training with no economic output for you, then that's fine. But if the 80% limit means that the individual has dropped below the national minimum wage, that's fine because they're not working. But if they are doing any training, then you have got to top up the amount to at least the national minimum wage amount for the training period. Employees on maternity and other family leave, normal rules for maternity and other forms of parental leave apply, but it does say that you can furlough individuals who are on, well, it says that you can claim through the scheme for enhanced earnings related contractual pay for employees who qualify for maternity leave, etc., which suggests that you can seek back an element of the enhancement that you might be giving to staff on maternity leave. And in that situation, it's a little unclear as to whether or not you've got to sort of formally furlough them, and whether you're claiming 80% of what you would have been paying them by way of enhancement. So there's a little bit more thinking to be done around that. But again, if that is a specific issue for organisations, then by all means, let's get together and have a conversation about it. How is furlough leave to be implemented? So we've looked at can you claim and for whom you can claim. Now, implementation. What steps must employers take to put employees on furlough leave? Well, number one, you've got to discuss the proposal with staff and make changes to the employment contract by agreement. There are a small number of contracts that allow people to be put on unpaid leave or to be given no work, but they are rare. So check the point in your contract, but almost certainly I would imagine your contract will not have that provision, and therefore you are left having to negotiate with your staff around it, and that's fine. I think a lot of staff appreciate that's going to be necessary, and you sell that to them on the basis that this is really just a temporary measure. This is not about being a poor performer or anything like that. This is just about getting the business through a very difficult time, and that's why we want to do it. Now, once you've agreed that with staff, and we'll just look at that in a bit more detail in a second, you've got to confirm it in writing, and that's a condition. You must send a letter or an email afterwards saying you are furloughed, and that's a condition of claim, and you've got to keep that record for 5 years. So before you get to that conversation, I suppose, or as part of it, you've got to decide which employees you are going to furlough. You've got to notify those employees of that fact, and then consider what consultation you need to go through. And I'm going to touch on collective consultation, not in any great detail, but just flag it that if there are 20 or more individuals, then there might be an obligation to go through a collective consultation process or some form of process, which you'll need to think through as part of your planning. You then get to a point, hopefully, where you agree to change with furloughed employees, and I imagine that a lot of employees will agree. And then you confirm that new status. As I say, it is an eligibility requirement. Ideally, give some thought to how long it's going to last, and you'll be saying we'll be keeping under review. Also, I think staff are going to want to know, what do you think are going to be the rules and the approach to us all coming back? And I think that's something that you're going to have to think about at the time of furloughing or during the furlough period, so that staff can be given as much information as possible. How does an employer decide who to put on furlough leave, and do you go through a redundancy type scoring exercise. I think not. I don't think there's a requirement that you do that. We're not terminating all these contracts. I mean, the more time you've got to consider it, and time is ticking down because the scheme is due to close at the end of May, unless we hear otherwise. We probably will hear otherwise, but for now there isn't a huge amount. I think we're about halfway through the scheme. The more time you've got to consider it, then obviously the better, and you can take a considered view to who we're going to furlough and why, and the approach you're going to take to that, and manage those either concerns about being furloughed or those concerns about not being furloughed. Can you rotate furlough leave employees? Yes, you can, but the starting point is you can furlough for a minimum of 3 weeks. And that's in keeping with the idea that people should be staying at home as much as possible. So if you do receive a request to furlough, or you feel it's good for morale to rotate, then by all means you can look at doing that, but it's got to be on a 3-week cycle at least. And also just on the 3-week point, if that doesn't change with the guidance, then if you haven't furloughed within 3 weeks of the 31st of May, then furloughing may not be possible. Because you won't have enough time to serve the full 3 weeks. So whether or not we'll have a change in that or an extension before that point, we'll wait and see. But just bear that in mind as well. If you are going to take advantage of the scheme, don't leave it too late and then find you miss out. Can an employee request that their employer puts them onto furlough leave? Well, yes, they can ask, but the fundamental position is that it's up to the employer. They do not have to agree. The employer's decision which employees to place on furlough, and that must be right. It's the employer who needs to manage this situation, but employers will naturally want to take on board volunteers and accommodate where and if they can. But do note though that if you are otherwise considering a redundancy process, you have to make sure that you can avoid redundancies, or you do all you possibly can to avoid redundancies, and where that is avoidable because of the furlough scheme, then you will want to ensure that you think about the scheme, because if you don't, and if it could have avoided redundancies by buying you some time to get through this, then it's going to potentially undermine the redundancy process and make it unfair. On the other side of that coin, if you had already in place a redundancy process and you were effectively going to make somebody redundant anyway, unrelated to the coronavirus crisis, then I don't think that means that you've got to furlough them. They might ask you to, but I think you run a risk, because you run a risk on both sides of the coin. But I think the risk is smaller on the side that says we won't furlough you because we may not get it back. If you look at the way the guidance is written, it does suggest that it's got to be related to the furloughing or the coronavirus situation. And if it's not, and it's unrelated, then it seems to me that somebody wouldn't be able to claim it. So just bear that point in mind. Collective consultation. So I don't want to bore people with this or scare people with it, but just need to cover it, which is that, and the guidance recognises this, that if you are going to put 20 people at risk of redundancy, or 20 or more people at risk of redundancy, there is a need in that situation to consider collective consultation and to go through the collective consultation process, which involves the appointment of representatives or consultation with your trade union, and a 30 or 45-day process. And that clearly doesn't fit very well with the urgency of the scheme. But it is arguable that it does arise if you do it as an alternative to redundancy. There is a defence, which is the special circumstance defence, which says that where it's not practical and there are special circumstances, then you don't have to go through the full process. I think we've got special circumstances. I don't think that anyone can realistically argue otherwise. But is it practical or not to go through it? Well, in terms of timeframes, probably not. But certainly you can do something, even if it's remote. So you're not absolved from all the responsibility. Now, the scheme is backed by the TUC, and so we might view that risk of collective consultation claims being low, because people won't necessarily want to come and hit their employers with these sorts of claims further on down the line, but it's possible. What you also can do to reduce the risk is to genuinely form the view, and I think it's a reasonable view to form, that people are not going to reject the furlough offer, or at least you'll get enough people agreeing that the remainder will be under 20, and therefore if you are in that situation, you would only be then moving on to phase 2, which is proposing redundancies if if those individuals don't agree, and if it's under 20, then the rules don't apply. Now, that argument, it can be attacked on, it's attackable, but it is nevertheless a middle ground, which I think is one that is a reasonable position for an employer to adopt. But again, just think through where you are on the risk register with that. What does the reimbursement cover? It's the lower of 80% of usual monthly wage costs, or £2,500, plus associated employer national insurance contributions and the minimum auto-enrolment pension contributions. So when working that out, you can include, I think, compulsory payments that are due under the contract, but not, if they're monetary, but not non-monetary benefits. So health insurance or provision of a car is not, doesn't go towards the monthly wage costs. Now, if somebody is on a salary, it's their gross salary as at the 28th of February 2020. Some contracts will specifically say you've got a base salary, others maybe not. So there might be a little bit of thinking to be done around what actually is the gross salary, where there are other monetary elements that you pay in addition to that by way of compulsory overtime or contractual overtime. If somebody is on irregular earnings, then the position is slightly different. You've got some choices. If they've been with you for 12 months or more, then it's either the average over the 2019-2020 tax year or the equivalent month in the previous year, whichever is the higher, so you can work that out. If they've been with you less than a year, then it's just an average of their monthly earnings since they started. And if somebody started in February 2020, their earnings so far should be prorated over the period up to the point when you furlough. And it's worth doing that calculation before you agree to furlough leave with the worker, because you are agreeing a contractual variation, and you want to make sure that A, the staff member knows what they can expect, and B, you want to know that it's going to match what you're going to claim back, or at least what you can realistically expect to get back. There are a number of points that are still unclear. The guidance says that a company director can be furloughed, and it says that those directors can carry on or fulfill their statutory duties. So they can do something. It's not that they can't do any work at all, but it's a little unclear as to just what statutory duties HMRC are going to consider should be done, as opposed to are nice to have, if you like. So there's a bit of uncertainty there. There is also some uncertainty around the situation where staff TUPE transfer after the 28th of February, whether or not they are in scope, because they will not be or have been on your payroll on the 28th of February, which, if you remember, is one of the criteria. Now, a lot of what I've read and seen suggests that that is not the intention, and that the intention is to cover them, and that would be right, I think. They ought to be protected. The whole thrust of TUPE is to ensure that protection. But it would be good just to get that absolutely confirmed, rather than having it in various sort of tweets that we've seen from within the government machine. And then you've got the whole issue around annual leave when on furlough leave, and whether somebody can take annual leave when on furlough leave or not. That's still a thorny issue. There are other more practical ways around it, like having somebody furlough for 3 weeks, then take some annual leave, and then be furloughed for 3 weeks, etc. What we do know is that annual leave accrues during the relevant period of furlough. And no doubt if somebody is on furlough, they're not going to want to take leave. So if people are not taking leave, or even cancelling leave more generally during this uncertain time, then just think through very carefully how you're going to manage that at the back end of the year when everybody wants to take their holiday, because you may not be able to accommodate that. So just get some early planning in around that and some early communications. And bear in mind that the working time rules have been changed to allow you a scope to allows you scope to carry over holiday for 2 years, but there are some sort of limitations to that. So all of that holiday piece is something just to additionally think about as to practically how you're going to manage the holiday that is going to accrue, but isn't necessarily going to be taken while on furlough leave. And that third time lucky brings me to the end of my session, and I'll go back over to our chair and see if we can answer any questions that might be arising.
Great, that's fantastic. That's fantastic, Paul, and that's really, really, really comprehensive. We've got a few questions. If you don't think I've asked the question correctly, just do unmute yourself and let me know. I've got a couple of questions. One, I think they're slightly related from Gaynor and Hassini, really about foreign nationals. And what about if somebody's foreign national working outside the UK but are not on the UK payroll? So basically an organisation is financing the cost of that role, but they're not on the UK payroll. Would they be eligible or not? I think
as the guidance is drafted, I think the answer is not.
Yeah.
There's a requirement that they're on the UK payroll. Whether there'll be any variation to that later to deal with those types of situation, I don't know. But as at now, I think the answer is unfortunately not. Right.
Okay. I've got a question from Deborah saying, regarding being registered online for PAYE, our payroll provider is enrolled, but they won't apply for furlough on our behalf. Does this mean our organisation has to enrol online too? And what does that mean in terms of multiple logins?
I'll be honest with you, I don't know the answer to the technical PAYE scheme process. I would first of all be looking to query with the payroll provider why they are not going to process it. That is something, if somebody has that very specific query, by all means drop me an email, but off the top of my head I have not had the joys of the administrative side of the payroll system, so I would be bluffing to say anything other than I don't know the answer to that. But if that questioner wants to email it over, I'll see if we can find out for you.
Fantastic, thanks Paul. I've got a couple of questions here from Robert. First one says, I understand that staff can be on reduced hours and be furloughed at the same time, but can these things run one after the other, so consecutively? For example, can someone be placed on reduced hours up until April the 30th and then on furlough from May the 1st onwards?
Yeah, I don't see why not. And that's just the same as placing anybody on furlough from May the 1st. And the only thing I think the individual would say, I want to be furloughed on my full hours. I don't want to be furloughed on 80% of what I've already agreed to cut back to. So you would be having them back onto full hours at the relevant point in the month, and then you would be furloughing them from that point on.
Okay. And Robert's other question is, if an employee resigns, can the employer place them on furlough for all or part of their notice period? And if an employee resigns while on furlough, would the furlough period count towards their notice period?
I think the notice period point is tricky. Now, the way the question is framed is, if somebody resigns during furlough, then it seems to me that would just be their notice period and they would tick it down and leave when they leave. But if the situation was slightly different, which is where the employer wants to serve notice, my view on that is that comes at a risk. The furlough scheme is there to enable employment to continue, and it's there to preserve jobs. It's not there to fund the notice periods, I don't think. And there's various phrases in the guidance which suggest that's the thinking. For example, it says it cannot be used to fund redundancy payments. So that would be the statutory redundancy payment, it seems to me. So the fact that it doesn't say it can't be used to fund notice might encourage you to think, yep, that's therefore doable. But by the same token, it doesn't expressly say that that's what it is for, or it doesn't expressly say that you can do that. So it's going to be open to HMRC to challenge that. So I would approach that with some caution if it was the employer deciding to issue a notice, because it might be that you've got an employer that says, well, I was going to actually remove you anyway, or I'm going to remove you anyway, and I might as well get the furlough scheme to pay for the notice pay. I think nobody's going to agree to be furloughed on 80% and then accept that as their notice pay. They're likely to say, if you're going to do that, at least I want 100%. And they've got no reason to agree to anything less. They're not saving their job. So most you'll claim back the 80, but even then I think it could be challenged later, but it's a little unclear.
Okay, and just finally one from me actually, which is just that we've had a couple of queries outside this session on the furlough swap scheme, which seems to be so people go and work for other organisations. So particularly there's groups of fundraisers who are going off to kind of be employed by other organisations who furloughed their own fundraising staff. Have you any sense of what the status is of that?
The guidance doesn't address it one way or another. On one reading, the guidance would seem to allow it, but at the other time, it would be perfectly, I think, plausible for HMRC to say, well, that was a deliberate avoidance tactic. That you just swapped one paid employee for a volunteer, and therefore we are going to look at those sorts of arrangements quite closely. The fact that they're quite well known and quite well thought about might well suggest that might be on HMRC's radar. How strict HMRC will be about that, I don't know. I mean, one would hope. I mean, the point is, lots of organisations desperately need to keep their funding streams coming in that example. And the scheme isn't really as fit for purpose for the sector as it might be, and that's a sector-specific sort of workaround. But I honestly can't sit here and say that I think it comes without risk. It will depend, I think, a little bit on how well that is understood by those sort of individual officers that will be asked to enforce this thing later on, I'm afraid. But I wish I could be more clear, but more guidance may well come out. We've had 3 lots of guidance in 2 weeks, so we who knows, Saturday afternoon it could get something else pops up with some clarity, but at the moment it is a little unclear, I'm afraid.
Great, thanks Paul. We await more guidance with interest. That's a fantastic session. I'm going to hand over to Steve Harper from Hays-Macintyre, who's a close partner of Bond, and over to you, Steve.
Thank you very much. So I would just try and get the screen share up, which hopefully you can all see. Is that working okay?
That's great.
Brilliant. Thank you very much. So by way of introduction, I'm a partner in the not-for-profit team at Hays-Macintyre, work with a range of organisations, but a particular specialism in working with international charities. I'm also a trustee of 2 of them. As you can imagine, one of the big areas I've been talking about with clients over the last few weeks is around budgets and forecasts, and in some cases around the issue of whether those clients are going concerns. And I'm hoping to address some of the key points in that this afternoon to close. Stephanie picked up on some of the relevant points around going concern already, and a good place to start is the 2 solvency tests. The first is cash flow, and that in simple terms is the organisation able to meet its liabilities as they fall due. The second test is the balance sheet test, and that's often looked at in conjunction with the cash flow test. And again, simply the balance sheet test is, does the charity have more assets than it has liabilities? Now, that sounds quite simple, but in some cases it's actually not quite as simple as it sounds, because there are issues such as defined benefit pension scheme liabilities, or in some cases assets that are held at cost, where cost might have been from 20 or 30 years ago, that actually mean that although the balance sheet potentially appears to show an issue, actually the cash flow side of the solvency doesn't pose an issue. So it is helpful to look at the 2 of them in conjunction with one another. Stephanie mentioned the concept of a statement of affairs, and that's really relevant where a charity is in liquidation or administration, and that really is a detailed balance sheet which fleshes out all of the assets and all of the liabilities of the charity at that point in time. Crucially, and I talked about valuation issues, that considers not just the book cost of the assets, but also the valuation of the assets. Now, in terms of going concern, one of the key points as an auditor that I tend to have the conversations with a client is at the point of approving the accounts, and in particular with December year-end clients where they've been looking at approving the accounts recently. It's been a very common conversation. It's really important to note that the assessment of going concern has to be made by the trustees. It can be supported by the management team, it can be checked by the auditors, and indeed it will be checked by the auditors, but that assessment has to be made by the trustees. And the question the trustees must consider is whether the charity can meet its liabilities and continue in operation for a sufficient period, and that's usually taken to be a minimum of 12 months from the date the accounts are approved. So it's not the balance sheet date, but it's the date the trustees are approving the accounts. The trustees, of course, should have sufficient information to make the assessment, which will be around the income and expenditure, the cash flow, and of course the reserves position. And what I always recommend is the preparation by the management team of a paper for the trustees, which sets out the reason that the charity is a going concern. But it's not just a year-end exercise, and it is important to keep those two solvency tests in mind through the year. Cash flow, I think, is really very, very important to focus on, and in challenging times such as this, it really is the cash flow that needs to be the big focus, and it's critical in particular where there are either low reserves or there is a low level of working capital because the reserves are tied up in assets or in some other ways. A few particular things to think about. Firstly, the impact of donors paying in arrears, which is quite common for international charities who are contracting with government bodies. I think firstly to think about is there scope for negotiation. I am aware of some government bodies being prepared to move from arrears to advance payments to support charity cash flow. If they're not, then it's thinking about what would the impact of a delay be and how would that affect the cash flow. Secondly, the process then of thinking about what assets are there to meet the liabilities as they fall due, and thinking about for example, conversion of debtors into cash and how that might be affected by the current situation. We've heard already about one part of the government assistance, the job retention scheme, with a portal to be launched on the 20th of April. And clearly that has a cash flow implication, because although the money will be claimed back at a later date, there's still a need to pay the employees in the meantime. There are, however, the options of VAT deferral as an automatic deferral, and also the option of a PAYE deferral, both until the 20th of June, and they can support cash flow. I think risk assessing the cash position and the different forms of income is very important, and just making sure that you've considered step by step the key areas of income and the level of risk that you think is attached to those. And I'm going to move on to scenario planning in a few minutes. Finally, on this slide, exchange rate volatility. Clearly, there is some significant volatility at the moment, and that may affect both the income side in terms of donors who might be paying in a foreign currency, and of course the expenditure, and especially where you're still trying to get money out to program offices and to partners, that may well affect that side of the equation too. So it adds an extra dimension of complexity at an already quite difficult time. Scenario planning, I think in an uncertain situation, and this is most definitively that, it's important that you're considering a range of different scenarios. I've seen different approaches to scenario planning. Some of them are led by income, and that's quite often the case where the charity might be able to scale down its costs quite easily. So I'm thinking there, particularly grant-making charities, and some of those are thought about. They've got their baseline of income budgeted, but what is the position if they come in at 80% of that, at 60% of that, and how do they cut their cloth accordingly? I've seen other approaches, again, taking a different tact of budgeting based on the period that we might spend in this lockdown position. So if it were to go on for 3 months total, how would that affect the financials? What about 6 months and then 9 months? And that can be quite helpful, especially for operational charities where the lockdown significantly impacts the operations. It's really important to identify the key decision points, and that could include the contractual commitments, it could include funding renewal, or in the worst case scenario, it could include wind-up costs, and understanding what, if it came to that, it would take for the charity to wind up in a solvent way that doesn't expose its beneficiaries to harm. And it is helpful, especially where perhaps reserves are low or there are significant difficulties, to make sure that you understand that position. Of course, very helpful to understand the cost base in terms of what is fixed, what is variable, and what scope there is to defer certain costs. And then thinking about the long-term impacts too. And I think at the moment it is really easy to be focused on survival, to be focused on short-term, and to some degree that is of course necessary. But I think it's worth thinking about what that means for the longer term. So, for example, charities with donations from regular givers on standing orders and direct debit will, I think, be thinking about the attrition rates of those donors, and we are seeing that the attrition rates are higher than they have been in the past. Not surprising. Now, in the short term, there might be the ability to actually cover that loss of income, because if you haven't got people out signing new people up for direct debits, for example, then actually there's probably a cost saving, and especially with that form of income, the payback period can be quite significant. So in the short term, actually, there might be quite a substantial saving. The issue there may well come actually in a year or 18 months down the line, where there's been a gradual attrition of donors, but without the ability to add significant numbers of new donors as well. So it is worth kind of cascading the impact through to the rest of the financial model. Worst case scenario I picked up on already. And then frequency of review is a question I've been asked quite recently, of how often should we be reviewing our financial model? And I think unfortunately the answer is as often as you think it's necessary. I've in a couple of cases been working with clients who are reviewing the position weekly because it's changing that much. My expectation would be that may start to settle down in a few cases, and we may go from there from weekly to fortnightly to monthly, and then perhaps back to a normal cycle. But I don't think there is a one size fits all approach. Clearly, the closer you are in terms of cash or not having sufficient assets, the more frequently you'll need to be reviewing those scenarios. There's a second area of complexity, I think, for many of you, for many of the international charities, in terms of restricted funds and dealing with activities funded by restricted funds. So a few things to think about. Firstly, make sure you understand the restrictions, and actually sometimes there is an approach of taking a too cautious approach to restrictions, especially in the good times. So it's making sure you really understand what exactly is restricted, and then what have you perhaps chosen to restrict, effectively to designate over and above that. Think about other conditions too, be it time periods. If you've got a grant or a contract that's very time limited, what are the conditions that come with that, and can you still meet those conditions? And the big issue I think a lot in this sector are facing is that you can possibly remove costs through furlough and for other measures, but actually if it's restricted funding, that quite often means that you are also losing the income. So it's not as simple as just deferring activities. It's actually quite a complex model to be thinking about. There are particular challenges here where you have salaries that are covered in different proportions by different donors, and especially where some of the donors are being more flexible than others. And my only advice really there is make sure that you're modelling out in terms of a funding grid or similar that shows exactly what's covered and by whom. And then I think it's thinking about the different skill sets. So can you, for example, if you're only continuing with half of the work in a particular area, think about the options in terms of furlough and other options for some of that team. It is a very, very difficult dynamic, and especially where you find that you've got particular staff members or very defined skill sets named in your funding agreements, that doesn't always help. But it is, I think, and I'll come on to this in a bit, about the relationships with the donors, and yeah, they are really very, very key. What I'm hearing from clients and other organisations is that some donors are being very, very helpful and very flexible, and are providing significant support in terms of being able to defer activities, looking for alternate ways that the same activity can happen, but in a different way. So if it's perhaps a face-to-face training course, that a webinar can replace it, and that kind of thing. Some are being a little bit slower to come to decisions, and I think it really is about having those kind of key relationships with your core donors. As part of any scenario planning, it's really key that you're focusing on the assumptions, and those key assumptions will vary substantially from charity to charity. So firstly, I think the key thing is identify what are the assumptions. And it sounds really basic, but actually it can be quite a helpful process to just sit down and tease out what's assumed and what's a known, and then thinking about which assumptions are the key ones. And what I mean by that in particular here is which assumptions would make a significant difference to the outcome of the model. And once you've identified those, sensitivity analysis is really helpful. And that sounds really complex and really techy, but actually it doesn't need to be. Now, I talked a little bit about donor retention, and that's quite a good example to give, because, for example, you might well assume that in a normal month you might lose 1% of your donors, so you might have doubled that to 2% to take into account this current situation. But actually you don't necessarily know that will be the case, because what you've assumed previously will perhaps not be applying now. So what it's about there is if you've made that assumption, maybe that it's 2%, but what actually happens if that's 3 or even 4? Does that affect your financial position materially in the short term, or actually is it a longer term effect to consider? Another area that I've been looking at with one charity very closely is about delivery of projects, and that's a situation where the charity is almost entirely funded by restricted funds, and they can do some but not all of what they've contracted with the donors to do, which effectively means they can earn some of the income but not all of the income. So they made a perfectly reasonable assumption of earning 50% of the income, which was not unreasonable. But my challenge to them was to think about how sensitive is that. So if it was only 40%, how much of an impact does it have on the income, and then how much of an impact does that have on the costs, and what does that do to the model overall? Similarly, if it's better than they thought of 60 or 70%, again, how does that affect the financial model? And then it's thinking about the follow-on effects too. So there are clearly many charities that have furloughed fundraising teams, but then what impact does that have on the ability of the charity to raise funds in the short term? And again, I think that's a bit case by case, and clearly where there are fundraisers dealing with events and so on, or raising direct debits by getting people in the street to sign up, clearly that's not activity that can happen right now. For others, it's a little bit more nuanced in terms of, for example, trusts and foundations and major donors. What's the potential return on that income, and how much are your fundraisers able to do working remotely from afar? And again, it will depend a lot on who your donors are, the nature of your work, and of course your fundraisers themselves. Reserves are really key to consider, and it is a good time to be really making sure that you understand very well your free reserves in terms of what do you have that is freely available to fund the charity, and making sure that the policy is well understood, not just by the finance team, but also by the wider senior team, by of course your trustees as well. And it can be a good time actually to consider the reserves policy, because it will have probably been set in a very different time. So is it still the right approach? And if you've made substantial assumptions in looking at your reserves policy, for example, if you've got a risk-based reserves policy and you've assumed a number of risks, do those assumptions still hold, or actually has the world moved on so much that you actually need to reconsider that? If you're looking at finalising your year-end accounts at the moment, communication to stakeholders in terms of the reserves policy is going to be really key in terms of explaining the amount of the funds you have, why you hold those funds, and how those are appropriate in the current situation. And actually, I think to some degree that might be working both ways. So I think if you have a low level of funds, then it's about explaining how the charity remains solvent, how you are still going to continue in operation. But if you have a high level of funds, or potentially it is perceived you have a high level of funds, then actually explaining why you have those funds so as not to put off potential donors. It's also important you're thinking about the reserves target and your reserves policy when you're considering your modelling too. Many organisations in the coming months are showing that their reserves will fall. So I think it's worth understanding when do you in that model fall below your reserves target? What does that mean for you? Does that mean that you're below an aspirational level, but actually you still have enough funds to continue in operation, or is that actually a minimum that's really quite serious for your organisation? And if so, what does that mean you do? Some good examples I've seen are charities where there is a change management plan in place that if they fall below their reserves policy, they have a preordained plan that's in place of how they will start to do it. It doesn't, of course, say what they're going to do, but it starts to talk about who they're going to get around the table to start to talk about it and how they will go about that. It's also worth considering different types of funds as well and what's freely available. And for example, you may have designated funds in a previous period, but actually you might well need to undesignate those funds because the need of the charity at this moment in time is much greater than the future designation that you had aimed to fulfill. Trustee engagement is something that Stephanie's picked up, so I'm not going to cover in a great amount of detail, but just a couple of things that I think are quite helpful to add to that. Firstly, if it's not trustee engagement by the full board of trustees, then it's worth thinking about how you're reporting back and just the process for doing that. There's always a balance, I think, at these times between having a small group that's agile and the need to engage all the trustees. And in one charity where I'm the treasurer, we actually had the conversation openly with the full board about the creation of a subgroup, and we explained how we would be reporting back as a subgroup to the full board, so that the full board were comfortable with the approach that we were taking. The other thing we've done there that I think works very well is we've actually set terms of reference for our little working group, and that perhaps actually sounds a little bit over the top and a bit too much when there's so much going on, but I personally found that helpful because it means that we know what we're doing as a subgroup, we know what we are trying to achieve, and it, I think, will stop the risk that subgroup starts to become a board executive or a sub-board, which is not what we want to do. We're a short-term group that are there because we may need to make quick decisions, and we may need to be able to deal with matters more rapidly than we can as a full board of trustees. The other point Stephanie's already covered very well, so I'm not going to I'm not going to dwell on those. The final point from me in this whistle-stop tour is financial reporting. And this is something I've been looking at in a lot of detail in the last few weeks with December year ends, and also a number of other clients that are looking to approve their accounts at the moment. You may well have seen that there's guidance from the SORP committee, which is advisory. However, I think actually it's incredibly helpful, because what they do is they take the SORP that you have to follow as a charity, and they are interpreting it in this current sort of COVID-19 situation, and they are explaining which bits of the SORP you particularly need to be thinking about in terms of preparing your financial report. So it is really very, very helpful to do this. In particular, there is a one-page effectively list of bullet points of all the areas to consider, and if you're thinking about your annual report at the moment, I would almost use that as a checklist. Some of those may not be relevant for you. Some, for example, will talk about situations where a charity has investment portfolios, and clearly for many international charities that's unfortunately not a relevant factor, but it is very helpful. A few key areas I've been talking about with clients in the trustees report are the fundraising disclosures, in terms of explaining the impact of COVID-19 on the ability of the charity to fundraise, and how the charity plans to address that going forward. I suspect one of the most pertinent ones is around the risks and uncertainties, and for many charities this is clearly a very, very significant risk. And of course the future plans, and that doesn't necessarily just have to be a negative or a defensive point about what you can't do, but actually for those charities that are involved in some way in responding to the pandemic, then actually talking about what you are doing, I think, is helpful to explain the work of the charity. The other one I've already referred to is the reserves policy. And then finally, in the financial statements, in the back half of the accounts, the two key areas are thinking about your going concern disclosure. That's often a little bit boilerplate, perhaps a little bit of a sort of very brief narrative that explains you've considered your budgets and forecasts. But what I'm certainly expecting to see is that most charities will have a much more thought out position about how they've assessed COVID-19 and how they're satisfied. It doesn't create a material uncertainty. And then for December and January, November year ends that are considering their accounts at the moment as well, the post-balance sheet events note explaining the impact of the virus, and explaining how it's been considered in putting those accounts together. For March year ends, I think that's going to be a little bit more complicated, perhaps, because of course it had happened in the financial year, but the full effects of it don't occur until probably after the end of the year. And if you have particular concerns there about valuation or about the impact on the numbers, I'd certainly encourage you to discuss those with your auditor or your independent examiner at an early stage, to try and agree how you'll deal with those particular things. So I've just about managed to do that whistle stop tour in the 25 minutes I promised Bond that I would do. So very happy to take any questions, and also my details are up on the slide. So if there's anything that you'd like to discuss with me at a later date, please do so, and I'd be very happy to have a conversation with you.
Thanks so much, Steve, for packing so much information in so quickly. We've got one question. I don't know whether you can answer it. I maybe Bond should have a go at answering it. But do you know if some donors are postponing their funding application deadlines? Is that something you've heard about or had notice of?
I haven't heard of donors postponing their funding application deadlines. I have seen some giving emergency funding rounds that they hadn't planned to do to try and try and respond to it. I wouldn't be surprised if there are some postponements, and especially some of, for example, the smaller old-fashioned family foundations where they're used to physically meeting as a board of trustees to try and approve everything. Unless they're able to get onto technologies like this, they may struggle to keep things going. I know, for example, of one charity that received in the post a cheque that had been written just before they'd vacated the offices due to COVID-19, and the charities that still work in that way may well be deferring, but I haven't heard of wide-scale deferrals at the moment.
Interesting. I mean, one of the, in terms of the feedback we've had at Bond about, in terms of their assessment of the way funders have approached this situation, we've generally had, generally the news has been very positive about the classic trusts and foundations, and that people have found that the ones that they have good relationships with are flexible, have been accommodating of changes and changes in financing as well. But I think it's a very variable picture in terms of DFIDs who have sent out very strong messages about being flexible from the top, but actually that's not really that's not filtering through to a sort of individual program level in any consistent way. So they're basically saying, negotiate with your senior reporting officer, but actually the senior reporting officers are behaving in different ways, the fund managers are behaving in different ways. And in fact, I was on a call the other day where some small NGOs were saying, oh, Mannion Daniels, they're fantastic, and other people were saying, Mannion Daniels, they're terrible, in one and the same call. And it's a lack of consistency there. And I think if anything, if there's a sort of common thread from all of your contributions today, I think it's been that keeping in contact with your key stakeholders, negotiating, telling them about your current situation, trying to reappraise it, but from that sort of, making sure that they understand what your organisation needs is a sort of key part of that, of the things that you need to do. You can't just sort of you've got to make your issues visible to the people that are funding you.
Yeah, I think that's absolutely right, that the communication is vital, but I do agree. Certainly what I've heard is some inconsistency in the approach that that some of the big institutional funders are taking. I have also seen some cases where organisations have gone back to their regular donors, and actually those regular trust foundations that are funding them have in some cases been open to conversation about either bringing forward tranches of funding where there's a multi-year agreement, or even extending funding. But clearly I think there is a huge pressure on all forms of funding, and all of these pots are finite, which is going to be a challenge, I think.
Okay, and I've got another question here from Evan Foy for you, Steve. It says, if the board have approved the accounts, but the accounts are not signed, do we still need to revise the accounts and update the post-balance sheet events note and going concern note?
Yeah, I think if you've got to a situation where you've approved but not signed the accounts, I would think it would be sensible to consider amending them before you approve. I think it's a conversation to have with your auditor or examiner, but I think that you're potentially in a position where the world has moved so much between the approval and the issue of those accounts that actually it would probably be sensible to critically consider what you've said. But I think it's a conversation that I definitely encourage you to have with your auditor.
Okay, brilliant. And another one from Katya. Can you advise where to go to get legal advice on international staff evacuations? In particular, we're grappling with issues around enforcing evacuation and the organisation's duty of care when individuals may choose to remain.
I wonder if that might be one for one of Bates Wells to perhaps pick up, as it's a more of a legal than an accounting matter.
Is that possible from Mindy or Paul? Paul.
Hello. What was? Sorry, I was distracted with looking at that question that came through on the payroll point. What was the question?
Yeah, it's can you advise where to get legal advice on international staff evacuations? In this instance, they're grappling with issues around enforcing the evacuation and the organisation's duty of care when individuals may choose to remain, which sounds interesting.
And I think the first point would be you've got to be looking to seek that advice from somebody within the relevant jurisdiction who can advise you on what jurisdictional or what local laws apply and are imposed on you, because every country has its own rules that would apply people that are working within its borders. We are able to put organisations in touch with a vast range of lawyers all over the world. So the starting point may well be to let us have that query, and then, or let us know what country it is, and then we'll certainly be able to source a lawyer in most countries where you're likely to have that that issue. Brilliant,
thanks, Paul. I think, Lena, am I right in saying that that's the end of, that's all the questions we've got? I think, if so, I'd just like to kind of wrap up and thank our speakers, Paul, Mindy, Stephanie and Steve, and thanks to Bates Wells and Hays-McIntyre. Thank you for all of you for sticking with us through a long session. You know, we'll supply the information on the in terms of other questions you might want to ask our panel post-event, but please keep the information coming into Bond. We're interested to know how you're getting on. We're happy to answer queries. We're happy to signpost you to people who can help you. So please keep talking to us and let us know about your organisations, how they're getting on. You know, we really look forward to seeing you at another webinar on a different subject. And thanks to you all, and have a really good and safe Easter. Thank you.
Goodbye.
Bye.
Thank you. Goodbye.
Bye.
Thank you.